Hey everybody, Mark Stiles, Principal Attorney at Stiles Law. I am here at Studio B at 892 with one of the real estate attorney team members at Stiles Law, Chris Holland. Chris, hey, thanks for coming down, buddy.
Thanks for having me, Mark. Hey out there. I'm here today to ask a question, Mark.
Okay.
One question that I get all the time from
Yeah.
our buyers. Do I need title insurance?
You know, Chris, that's a great question. We do get that a lot, and although it is optional, we highly recommend getting owner's title insurance for the consumer.
That's great information, Mark, but what they always ask me is, didn't you, as attorneys, do a title exam before the closing?
You know, it's a great question. We did, but we do a limited title exam required by statute that only goes back a certain amount of time. But more importantly than that, Chris, is a lot of the title claims that actually occur happen outside of the public record. So if we're doing a public record title exam, we can only see what is actually recorded. A lot of times things happen that aren't on the title exam.
Like what? What would be not on the title exam that could happen to a purchaser of property?
Great question again, Chris. One of the things that we see a lot is in probate. So if somebody were left out of an estate, then that heir may actually have a claim to it. But without being on the estate, we wouldn't know that. Another example that I just heard about recently, a colleague of ours did a closing, a real estate closing. The buyer did not purchase title insurance, and a claim was filed for adverse possession the very next day after they purchased the property.
What is adverse possession?
So what happened was there was neighbors, and one of the neighbors next to the property that this fellow purchased was using their property. They were using a big portion of the new buyer's yard, but there's nothing on the public record about that. They filed an action of adverse possession saying, now that I've used that yard for X amount of years, I own that yard. And because it wasn't on the public record, the new buyer would never know about it. The closing attorney would not be able to find that in any public record search. Therefore, the new homeowner has to defend that claim without any title insurance. Where title insurance had been purchased, the title insurance company would have come in and defended that claim and paid for the attorneys.
So that's great information on adverse possession, Mark, but what other matters should come up? Things that aren't so outrageous and far-fetched as possible.
You know, great question. Very rarely is there a huge title claim like that. I mean, there's been some in the papers locally here. Wrexham Beach was one. And there's a lot of other big condominium complexes that have fallen into litigation where if you didn't have title insurance, you wouldn't be able to transfer the property. But that's really where the rubber hits the road. If you have title insurance and something comes up, whether it's administerial, fraudulent, fake, non-essential,
Right.
but it's going to hold up your closing. If you have title insurance, the title insurance company who's already on the hook is going to continue with that liability, allow the closing to happen for the new owner, and then fix the problem behind the scenes after the closing occurred.
And one of the big questions I get a lot, Mark, is how is this paid? Is this life insurance or collision insurance or fire insurance?
Well, that's the beauty
How
of
is it
title.
paid?
That's the beauty of title insurance. So it's not paid annually. You pay it at the closing at a reduced rate because you're typically already purchasing the bank's policy.
Okay.
You pay it once and you own it as long as you live in the property.
Okay, so there's no monthly premiums, no annual premiums?
No, you pay once at the closing and that's it.
That's
you
it.
own it for life.
That's great. So, Mark, you mentioned a loan policy. Wouldn't the loan policy also cover our buyer, the purchaser of the real estate?
You know, that's a great question. Probably the best question of this whole conversation. That's a common misconception that a lot of people say, okay, I'm buying a policy, it should cover me. But if there's a claim and someone comes knocking on your door and makes a claim of ownership of your property, that's
Right.
what you're covering is the property that you own, the dirt, the boundaries of
Right.
your property. If
Okay.
someone comes knocking on the door and says, I own a portion of your property, I own your property, whatever, and you don't have an owner's policy, but you have a loan policy, you go to the bank, they're going to deny the claim. And the reason being is that you're making payments on your mortgage. The loan policy won't trigger until it actually becomes an owner's policy. So the only way a loan policy would take effect is if the bank actually owned the property. So you would have to go into default and lose your property for that loan policy to take effect. They will deny a claim if it's the owner trying to make a claim on a loan policy.
So what you're saying is only a home that's in foreclosure, at that point it becomes,
So in essence, it becomes owned by the bank.
Right.
So an owner's policy is for the consumer. A loan policy is for the bank. But there is no claim, there is no action against the loan policy until that bank owns the property.
all right.
Now, folks, if you have any other questions, please look at our blog at stiles-law.com. We have more information about title insurance. And obviously, if you have any questions, please give us, any one of our attorneys on the real estate team, a phone call at 781-319-1900. Thanks for listening, and I hope this was very helpful for you.